change it for you today, okay?
Okay.
And if he gets a sense that you're hesitating or that you don't want to do it, he'll cancel the whole thing. So just don't hesitate when he asks you the questions, and we don't add anything to the summary of the facts, all right? Because that's what a trial would have been for.
Okay.
All right. I made a salad on Sunday for my lunch on Monday, and I was out on Monday, and I didn't have it today. Would it still be good tomorrow, or should I probably have it for dinner tonight?
Blake.
Thank you, Your Honor. We're here today in the state of Ohio versus Dennis Hunter, case number 674. Your Honor, Mr. Hunter is present. He is represented by counsel, Mr. Chad Mulkey. Your Honor, a one-count information has been filed in this case charging the defendant with domestic violence, a felony in the 4th degree, in violation of 2919.25a. Your Honor, it is the state's understanding, and the state anticipates that Mr. Hunter will enter a guilty plea to the one count that has been filed by way of information. If that plea is forthcoming, Your Honor, the state anticipates asking this court to order a pre-sentence report and drug and alcohol assessment, as well as a victim impact statement prior to sentencing. We do not have an agreement with respect to sentencing. Thank you, Your Honor.
Mulkey.
That's all accurate, Your Honor. I discussed the case with him in detail. He understands what we're doing here today. I believe he's competent to go forward and anticipate a guilty plea forthcoming.
Mr. Hunter, how old are you?
66, sir.
How far did you go through school?
Technical college.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
You ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of this information?
Yes, sir.
Have any questions about it?
Yes, sir.
Do you have any questions about the information?
No, sir.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorney?
Yes, sir.
Are you going to waive that right?
Yes, sir.
All right, this is the first one we talked about here. Sign there. I know it's hard, but yep. All right, we'll just leave that there for the...
Honors, for the record, I've witnessed Mr. Hunter and defense counsel review and sign the written waiver of indictment. I've also affixed my signature to it with permission to approach the attorney.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Mulkey some more, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Domestic violence is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
Are you currently on post-release control to the parole authority?
No, sir.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for a violation. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
Ms. Blake, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had the matter proceeded to trial, the state of Ohio would have proven the following beyond a reasonable doubt. On May 5th of this year in Willoughby, Lake County, Ohio, the defendant, Mr. Hunter, and his girlfriend, Gina Suber, were living together as they had been for approximately the prior 4 years. They were living together at their residence in Willoughby. A verbal argument between the two ensued. Words were exchanged. At that point, Your Honor, that verbal argument escalated. During that time, Mr. Hunter struck Ms. Suber in the side of the head and face area. That led to her having difficulty with that side of her head as well as her ear and her neck. She was transported to the emergency room at Lake West for evaluation and treatment. Your Honor, Mr. Hunter has previously been convicted of domestic violence. That conviction, or at least the conviction that forms the basis of the prior, for purposes of this information, was out of the Willoughby Municipal Court. That case number is 12 CRB 0764, and the conviction is dated March 27th, 2012. Your Honor, had this matter proceeded to trial, that is what the state would have proven.
Thank you. Mr. Mulkey, anything to add to those facts?
We have nothing to add, Your Honor. Thank you.
Mr. Hunter, did you hear what Ms. Blake said the facts would show if the case went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to domestic violence, a felony of the 4th degree?
Guilty.
Mr. Mulkey?
Thank you, Judge. Approach, Judge.
Right here.
Oh, sign your name here. And then 7/21/26 there. All right. You're welcome.
Your Honor, just for the record, I've witnessed Mr. Hunter and Mr. Mulkey review and sign the written plea of guilty and judgment entry, and I now have also affixed my signature to this document, and with the court's permission to approach, I would return the document to the court at this time.
Mr. Hunter, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
All right, I will accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find him to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of domestic violence of felony 4. I'll refer this for a pre-sentence report. Drug and alcohol evaluation, victim impact statement. Sentencing will be September 2nd, 9:30, and the bond remains revoked. Anything else, Ms. Blake?
Nothing from the state, thank you, Your Honor.
Mr. Mulkey?
Nothing, Your Honor. Thank you.
Feel better?
Yeah, thank you.
Let me know how the salad turns out for you.
I think it'll be all right.
All right, take care.
Thanks for the salad advice.
I hope it doesn't fail you.
I hope I don't get that.